Is there ever an instance where I would actually go ahead and compliment my opponent, my adversary, the opposing lawyer? Would you like to know the answer? Come join me for a walk as I head to the train into the city today. I have to drop off my laundry as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes. In some very rare instances, I will actually compliment my opponent. Now, you might be thinking, okay, why am I talking about this? I'll tell you why. The other day, my client was being questioned in a process called a deposition. That's a question and answer session where the attorney who represented the various doctors had an opportunity to go ahead and question my client about what happened, what she knew, what she remembered, and about conversations that she had. The interesting thing here was that my client happened to be the legal representative of the estate of her family member who had died, and she had very little to no information about the details of the malpractice in this particular case. Despite knowing that fact, my opposing attorney, the opposing lawyer, took 7 hours to go ahead and question my client about things that she knew nothing about. That was frustrating, and we were fighting throughout the entire course of the deposition about what? About improperly phrased questions, about things that she knew nothing about. And the defense attorney, in my opinion, was doing it simply, in my opinion, for billing purposes, to try and drag out every last minute she could, because in New York, there is a limit as to how long you can actually question a witness in a medical malpractice case, in an accident case, and even in a wrongful death case. And that limit is 7 hours. In the past, it used to be that if a defense attorney felt that they needed to question you longer, they would bring you back for another day, and we would actually have to bring you back so that they could complete their questioning. Nowadays, they're only permitted a maximum of 7 hours. You might be thinking, 7 hours? How is that possible? How could somebody ask you questions for 7 hours? The reality is that they have hundreds, if not thousands, of questions to ask. So now let's get back to why I'm actually talking about this in this particular video. I had such a difficult time with this defense attorney that we were fighting and arguing, not fighting, but literally arguing about many of the questions that she was asking my client because I felt that they were inappropriate. Many times I would make an objection, the defense attorney would say that's not a proper objection, and we would disagree. And instead of going ahead and asking the next set of questions, she would sit and argue with me for a few moments. And that tended to be very frustrating. So the day before, I had also had another deposition with a different defense attorney, and my client was questioned. And now, during the course of that questioning, this attorney was on point. She was focused. My client, despite telling her to answer only the questions being asked, felt the need to try and go on and give details about things that she was not asked about. My client, despite my best instructions multiple times to answer only the question, felt it was so important for her to understand the details of everything that happened before and everything that happened after. So, for example, my client was asked a question such as, hey, on this date, did you have a conversation with Dr. Jones? And the answer should be either yes, no, or I don't remember, right? Instead, my client started to give 5-minute explanations about why she didn't remember, and maybe she did, and she's not sure, and then she thought, okay, well, let me tell you about the 5 minutes leading up to that possible conversation, and I had to repeatedly tell my client to please only answer the question that she was asked. Now, to this defense lawyer's credit, instead of going down into every single rabbit hole that opened up potentially other avenues for the defense lawyer to ask questions about that had nothing whatsoever to do with the claims in the case, this defense lawyer stayed right on point. This defense lawyer did not follow those rabbit holes. This defense lawyer kept focused, and that was remarkable. So the next day, after I had this experience with this other defense lawyer who I was arguing with for most of the deposition, I decided to pick up the phone and call my adversary from the deposition the day before. And I called her up and I said very simply, listen, I just want to let you know, I thought that your questioning of my client was very impressive. And she could not believe that I, as a plaintiff's lawyer, as a lawyer who represents an injured patient, would actually take the time out of my day to call her and to compliment her on the job that she had done when questioning my client. Now, some of you watching this may say, I don't understand. How could you call an opponent and actually compliment them? You know why? Because I guarantee you that I made her day. And it did not detract one bit from what I was doing. It did not detract one bit from the work I was doing for my client. Complimenting her did nothing whatsoever to hurt my client, to hurt me, to hurt my reputation, or anything like that. Instead, what did I do? I complimented her for doing a great job. And she really appreciated that. And she said to me, you know, it is extremely rare. In fact, she's never had a plaintiff's attorney, an attorney who represents an injured patient or an injured victim, compliment her for the work she had done. You're watching this and you're thinking, wait a second, how can you actually tell your sworn opponent, somebody who is doing everything possible to fight your client's case, that you actually think that they did a good job? The reality is that they are human beings. They're doing a job to represent their clients as best as possible. I likewise am doing the same exact thing. And simply by complimenting the opposing attorney, and it doesn't happen often, but in this particular case, I felt it was well deserved. It doesn't do anything to detract from me, from my case, my client's case, or what I'm fighting for. It's simply a goodwill gesture, and in this particular instance, I think well deserved. You know, there are people who are going to disagree and say, I would never do that for an opposing attorney. I would never tell them that. And you know what? There are many attorneys who simply don't deserve that accolade. They don't deserve that compliment. And that's perfectly fine. But in this one instance, there's nothing wrong with picking up the phone. Or if this had been done in person, after my client had left the room, I simply would have turned to her and said, I think you did a great job questioning my client. You know, you should be proud of yourself. And not in a sarcastic way, but in a true, genuine way. So why do I share this quick information with you? I share it with you because this is something that nobody ever thinks about. And it was something that was so interesting and such a big contrast between the two different depositions with the two different defense attorneys who had similar experience in terms of the length of time that they had been practicing. So why do I share this with you? I share this with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.